Greetings, slackers. It is October 21st, 2016, and I've got some more news to share with you, and you'll definitely want to know about this. This is over on OregonLive.com. Defense rights trump privacy rights in rape case appeals court rules. And this is by Amy Green. The Oregon Court of Appeals ruled Wednesday that the right of a man convicted of rape to defend himself outweighs the privacy right of his accuser to keep the contents of her computer hard drive secret. The decision could have wide implications, paving the way for defendants charged with a variety of crimes to gain access to emails, Google searches, texts, and other information contained on an alleged victim's computer or cell phone. A higher court in Oregon has never before made such a finding, said Portland defense attorney Stephen Hells, who represented the man in the rape case. It puts computer and cell phone evidence on par with other types of evidence now accessible to defendants, such as photographs or letters, he said. The appeals court ruled that a 25-year-old woman who reported that she was beaten and raped in 2011 by a 37-year-old Ben doctor must turn over her computer hard drive to a forensic expert to comb through for information that could help exonerate the doctor. A Dutchess County circuit judge will privately review the information, then decide whether any evidence found on the hard drive should be given to the defense. If significant evidence is found, the judge could grant defendant Thomas Harry Bray a new trial, House said. Bray was convinced in 2012 after an 8-day trial. The woman testified that her first date via Match.com with the doctor went horribly wrong moments after she stepped into Bray's downtown condo for a glass of wine. She told a jury that Bray slapped, raped, sodomized, and strangled her until she passed out. She said she thought she was going to die, so she took strands of hair that Bray had pulled from her head and scattered them around the condo in hopes that police investigating her disappearance would know she was there. Bray is now serving a 25-year prison sentence in a Umatilla prison. The woman's fight to keep Bray from seeing her Google search records, emails, and other electronic information landed her in the national spotlight as the Oregonian Oregon Live featured her story, and she later appeared on NBC's Today Show. Victims' rights advocates applauded her for her courage. Howes, the attorney who represented Bray during trial, had sought access to the woman's Google search records, the terms she had queried, and the website she had visited in an effort to question her motives. Howes contended that the woman searched the internet to determine whether Bray was really a doctor and therefore wealthy enough to falsely sue for rape, according to the appeals court summary of the case. The woman had filed a $2 million civil suit against Bray, but dropped it after he was convicted. She says she filed the lawsuit to hold Bray accountable if he had been acquitted. The prosecution argued that allowing a computer search would violate the woman's constitutional privacy rights as an unreasonable search and seizure. Fourth Amendment there. Dutchess County Circuit Judge Stephen Tickton agreed that the woman's hard drive shouldn't be searched, but the Court of Appeals overturned that decision. It would have ruled differently if Bray had sought unlimited access to the contents of the woman's computer, the court said, but Bray's subpoena was narrow and sought a screening by a judge. The appeals court likened the Ben rape case to that of someone charged with home burglary. He knows that the interior of the victim's home is protected by video surveillance cameras, the appeals court wrote. To prove that another person, not the defendant, committed the burglary, the defendant subpoenaed the videotape, under the condition that a technician screens it for information and a judge determines if segments should be given to the defense. The appeals court wrote that prosecutors would oppose the review of the video, arguing that it violates the victim's privacy rights to the inside of their home, but such an argument is untenable, the court wrote. The Dutchess County District Attorney's Office couldn't be reached for comment for this story Wednesday. In the same ruling, the Appellate Court affirmed the lower court's decision not to throw out the criminal charges against Bray based on the argument that the District Attorney's Office had committed misconduct. Judges Stephen Tickton and A. Michael Adler initially had ordered the District Attorney's Office to get the woman's search history from Google, but the prosecution strongly disagreed based on the woman's privacy interests and defied that order with delays and refusals to act for months, according to the appeals court summary. The appeals court said no error occurred because the lower court ultimately decided that it didn't have the legal authority to order the prosecution to seek the Google records. The appeals court, however, issued a scathing rebuke to the prosecution. Quote, "We find that state's conduct at trial to be seriously disturbing," wrote appeals court senior judge David Schuman. Quote, "Its lack of good faith with respect to obtaining the Google information was significantly worse than foot dragging, delay, and resistance. It was repeated, intentional, and conceded defiance of a court order. Such defiance is nothing short of an attack on the judicial system itself." The ruling was made by a 3-panel judge of the appeals court. And so I'll just stop it right there. If you want to know their names, you can read them. But this has some potential implications to change a lot of things. If you look back through some of the other news that I have done, this relates to another case, an earlier case, where what's going on is you have these smartphones that you're using. And so right now, courts have largely determined if you don't have a password on your phone and the officer retrieves it, that they can get the contents off of there, because for some reason, a smartphone in your possession is not viewed as personal property, nor is the digital content that's stored on it. So this case gets kind of dicey because, see, when we get into computers, your computer is a physical object, and so that belongs to you. But where this could potentially take things to is a whole nother level by opening up a can of worms and saying that digital data is not subject to the same privacy laws as, for instance, a physical object. So real world objects that exist, that's subject to the Fourth Amendment, but the Fourth Amendment does not apply to digital content or digital data, which means that everything from your tweets, your text messages, to even your personal emails are at risk here. And how many of us on a daily basis have put a lot or some of our lives out there online through social media, or having a back and forth dialogue with someone through email or a chat messenger type service? Well, see, what you may not know is that just like with text messages and Skype chats and all this stuff, there's a log that's being kept, and that log is keeping metadata and potentially other data about not the conversation per se that took place, but to show that these two people talked and it was between this time and this time. So it timestamps and it keeps a log of this stuff. And so that's the type of digital data that is not subject to the Fourth Amendment. And so if this case goes to court and they decide differently, that could definitely and potentially impact your smartphone and definitely your conversations. Because, hey, if you are, let's just say, having a conversation with someone and it's supposed to be harmless and innocent, but it starts getting deeper and some things get discussed, well, you meant to share it with that person and it was supposed to be private, but if they turn it into, let's say, a lawsuit or something like that, your words can be used against you. So you'll definitely want to be careful about all this stuff as you move forward, especially after hearing this news, because I don't think that they'll be able to overturn the Fourth Amendment as it stands, but there could be something else that could come out of this. We'll have to sit back and see. I'm going to follow this one. The link to this will be down in the description box. Leave me some thoughts and comments on, what you think about this. And, if you put a lot of information in your smartphone, such as pictures, and you store messages and stuff like that, like I said, you could be putting yourself at potential risk because all that stuff can be used against you if your phone gets lost. There's one stolen, or better yet, gets taken from you and in a seizure by the police or other law enforcement agencies. So something privacy and security to think about. Anyways, that's going to do it for this article and this video. I will catch you in the next one.